having any travel plans. I know there are few people will be planning to travel either for wedding or some other reasons, but please weigh in options. Uh, and be prepared psychologically to stay for a long time there to get an appointment and come back to US if you do not have a valid visa in your passports. Those are the things which I would like to bring you to your attention and everything. And one more thing also is we got several calls from the people from whom we filed I-485s in the month of October about the receipting of those cases. And those cases we started receiving the receipts. For a few cases we received the receipts, but not for all. But usually we are assuming that they're taking 5 to 6 weeks to issue the receipts for all these cases. So probably in a week or so, we will start seeing the receipts coming in for all the cases that have been filed in the month of October, especially the 485 cases with the downgrade I-140s, or even the regular I-485s also based upon the filing charts for those individuals basically. And that's the main thing which I would like to talk to in this call. Now we would like to open the Q&A, and we will have the Q&A for next 30 minutes. And if
Hello. Yes, sir.
thank you. Thank you. Somehow my call has been dropped, and sorry for that. And thanks for unmuting me. Can you all hear me? When can you hear me? Yeah, sorry for that. Somehow my call has been dropped. As I said, let's open for the Q&A now, and we'll take Q&A for next half an hour, and we'll end this call today, this week, that way.
Q&A session has started.
Hello.
Hello. Bhanu
Yes,
garu,
sir.
good afternoon, sir.
Good afternoon. Tell me, sir, how can I help?
Thank you for doing all this, sir. Bhanu garu, this is Kumar here. A question, sir. This is in regards to the downgrade for the downgrade along with the 485.
Mm-hmm.
I remember in your one of the previous calls you mentioned something about you could potentially request for premium of the I-140 downgrade as long as your application goes back to the same service center, something on those lines. So, sorry, go ahead, sir.
Can I interrupt there? Is that okay if I interrupt?
Yes, sir. Please.
Yeah. So I said that basically that once your case is receipted I-140, okay, then you can actually try to convert that into premium processing because it is under the discretion of the USCIS service center over there. Okay. You do not. I always advise people not to file initially when they're submitting I-140 and 485 in premium processing, especially when they're downgrading from EB2 to EB3 and using the same existing EB2 label for that.
Okay.
Okay. Yeah.
Yes, sir.
Oh,
yes, sir. So my question, yes, sir. So my question is, especially now, with this downgrade, it's going to be sort of a concurrent processing, right? So I just wanted to understand that, like, say, okay, we don't request the premium processing, and assuming the I-140 will take its usual course of how many ever months it needs. Will that really slow down the 485 processing, or is it genuinely concurrent and they would issue out the EAD even though the I-140 is still being processed? Some guidance in that area, sir.
Yeah, they will issue the EAD irrespective whether your I-140 is approved or not. Okay.
Got it.
And I-140 is adjudicated separately, 485 is adjudicated separately, EADs are adjudicated separately. they all adjudicated at the same time based upon FIFO basis, first in, first out basis, and as well as the prior to dates availability basis. Basically, for example, they will adjudicate your I-140 on the side, they'll adjudicate your 485 on the side. If your 485 is ready, they'll keep it ready to whether to approve it or deny it based upon your I-140 approval and as well as the prior to dates availability, final action dates availability at that time. Okay, but EAD is basically a separate application which you are filing with the 485, and they're going to adjudicate that separately, and they're going to issue EAD within those processing times if your 485 is still pending at that time. Okay.
Got it. Okay, sir. Yeah. Yes, sir. Thank you. That's all, sir. Thank you.
Sure. Next caller, please.
Hello, Bhanu. This is Prashant. So my question is like, let's say if you apply the 485 as part of this EB3 downgrade, and if you use EAD, then automatically the H1 will be automatically not valid. Is it right?
That's correct. You will be losing your H1B status because if you use your EAD, that means you're no longer on H1B status.
Okay. So let's say in that case, if the EB2 dates moved later on, then can we upgrade at that time, or
you should be able to upgrade?
Okay. So even if you use the EAD, it doesn't matter. We can still upgrade to EB2.
Absolutely. As long as you're with the same employer, you'll be able to upgrade.
Awesome. One other thing is, like, I heard recently the public charge 944 is not required. A court has given some order.
No. Basically, see what happened is the Illinois court actually said that we should not apply that anymore. Basically, that's what they said. But however, again, in the Seventh Circuit case, I believe, the court actually said that 944 is basically valid, and everybody has to provide that information. Basically, the court ruled in favor of the USCIS. Therefore, we never stopped including I-944, irrespective of whatever it is, basically because we don't want unnecessarily, erroneously, or whatever it is, basically USCIS deny the application. Even that brief few days, actually maybe 2 days or 3 days in between, where Illinois court ruling was standing, basically. We knew that this is what is going to happen. Therefore, we always included the 944s, irrespective of whatever it is. So, unfortunately, you have to still provide information for 944 when you file 485. Maybe that may change once the new administration comes. We do not know, because it's very likely that new administration will be more pro Hispanic, especially DACA. Professional DACA individuals and Hispanic individuals who are coming into this country. They are not just for the higher income migration. So we may see changes making to the policy implementation of the 944 in the new administration, but we do not know when that's going to happen also. Once the new administration comes into power, which is basically from January 20, 2020. Wow.
Okay.
I'm sorry, January 20, 2020. Okay. Thank you.
Okay. Yeah, thank you, sir.
You're welcome, sir. Next caller, please.
Hello, Bhanu. This is Krishna from New Jersey. This is just a follow-up question from the previous call. So if I tend to use my EAD that's received through EB3 and abandoning the H1B status, so can I actually work for a lower wage than what is mentioned in PERMOR 140?
Yeah, absolutely. You can work, sir. There's nothing.
Will there be any issue for the final adjudication of I-485 or a GC interview?
No, there won't be. The point here is the green card position is a prospective position all the time. That means you are supposed to work in that position once you get your green card.
Okay. And also, can I, for a brief time, can I also stay not working, like taking a break from work? Would that have any impact on my GC?
If it's for a temporary period of time, it's understandable. But the point is if you are not working, then you do not have any bona fide offer of employment in this country, right? Or at least your employers must say that he has taken a break for a while, but he'll be coming and joining in the company, and we still have a bona fide offer of employment at the time. So there's a question of genuinity and bona fideness will come into the situation if somebody doesn't work in between. If there are circumstances where it forces them not to work because of their health or some other personal inconveniences, it's understandable.
Okay, got it. Got it. Thank you so much. And also, will I have any status to actually sponsor for my spouse who is in India if I'm on a EAD? Yeah.
I didn't understand the question, sir. Can you repeat?
If I'm working on an EAD, and do I have any underlying status to sponsor a visa for my spouse who will be in India?
No, your wife can always join as a following to join FTJ to you, basically. Okay, she'll have the same priority date as your green card, irrespective whether you have a green card or not. If she's married to you prior to you, while
no, after the adjustment was applied. Like right now I'm single, so.
Yeah, even after the adjustment of status applied, but prior to getting your green card. Okay.
Okay.
If you marry her, if you marry someone, that individual as a spouse will be eligible to apply for green card benefits as an FTJ applicant, following to join applicant. Okay?
Got it. Thank you so much, sir.
You're welcome, sir. Yeah. Next caller, please.
Hello, Bhanu sir. Can you hear me?
Yeah, I can hear you, Andy.
Yeah. Thank you, sir, for holding this call. It definitely helps most of us. I just have a quick question. I was trying to book an appointment interview date for H4 for my wife. But every time I go to this travel docs page and then click on I see a lot of dates are available for Chennai and for New Delhi office. But when I click on the date and move on to the next page, again, it shows that there are no appointment dates available.
Absolutely. Yeah, tell me, sir. Tell me.
So actually, I did this for like past 1 month, but I'm doing this every two times in a day. But then I called the customer care. They said that actually no interview dates are available. Those dates which you see are actually biometric dates. So my question is like, how they just told me just keep on trying because the dates are being released on a very limited basis. But I don't know if I'm not able to make a request, then of course I'm not able to log in an emergency request too. So how long I have to do this? Like I don't know. The customer care didn't give a very satisfactory answer. I just wanted to know if you have any idea.
Unfortunately, nobody knows basically because yesterday also, U.S. Embassy in India, basically from Delhi, Delhi Embassy, that's what we generally call U.S. Embassy in Delhi in India, gave a notification yesterday through tweet saying that even including emergency appointments, it's taking too much delay in India. They do not have enough slots available right now. It's taking too much time. Therefore, they're advising people to plan accordingly to apply for visas in India. Okay? So that's why they're advising people not to travel to India unless they're psychologically prepared to stay for a long period of time there, because we do not know when the consulates are going to open. Until then, my assumption is basically is the current administration is not going to do anything until they are in the power. That is till January 2021. Hopefully everything goes normally, because who knows what's going on politically in this country. But if we have a belief in the American system, American institutions, then the new administration is going to come into power from January 2021, then things may become different at that time, because they already commented exactly what kind of an executive orders the President-elect Biden is going to issue if it pertains to immigration. Basically, it's said that main thing is going to remove the travel restrictions from 13 African countries, basically majority Muslim countries, and other travel restrictions also. Very likely what we are basically seeing for H-1B program and other things, and is going to implement and secure DACA program as well, so that 750,000 people who are in this country on the program will be protected right now, which they are not. So those are the things we are going to see some kind of an action on immigration policy from the new administration. But until then, I will not hope when the visa appointments will be open in the Indian consulates, basically.
Okay, sir. Thank you so much for answering the query. Thank you so much.
Yeah.
Hello, Bhanu sir. I have an H-1B approval and H-4 application pending. Let's say if I would like to have a transfer to another employer, what are the implications of the existing H-4 application pending?
Can you said that you have an H-1B application pending, H-1B petition is pending for you, and H-4 application is pending for your spouse. That's what you said. Am I right?
No, H-1B is approved.
Only H-4 is pending.
Yes.
Okay. And does she have a valid status now, or just she's in the authorized period of stay because of her extension filed and pending?
Yes, extension filed and pending.
Okay. She doesn't have a valid I-94 right now. That's what you mean to say.
Yes.
Yeah. And when you file for a new transfer, basically, you apply one more H-4 application also, basically. Okay. And they're going to adjudicate both H-4s. Most likely, they will approve the existing H-4 till the date you are legally employed with your employer, and they're going to approve the new H-4 which you're going to file with your transfer till the date your transfer is approved. But you expect an RFE on both the cases for her.
Okay. But if the old employer withdraws H-1B, how does it go?
It doesn't matter. It doesn't matter. You cannot withdraw H-4. You can only withdraw H-1B. It doesn't matter.
Doesn't matter. Okay. Yeah. Thank you, sir.
Thank you very much. Yeah. Next caller, please.
Hello, Bhanu. This is Tarun.
Yes, Tarun.
Yeah. So I have a weird scenario. I don't know how to say. Yeah. So initially, I was employed from my employer, and I traveled back to India in February, and I came back in June. And so, like, due to flight inoperations and all this, I was stuck in India, and I have lost my job. I mean, I was furloughed initially on May 1st, and my last paycheck was on May 15th, and then I came back on June 21st, without having a job. But my employer did not revoke or withdraw my petition, as he wanted me to put in a different project. So after coming on non-compete agreement, he asked me either you can find a job, or maybe either I can find a job on my own, or maybe if I find a job from his company, he can put me. But later on, after 60 days grace period, started on June 21st, like whenever I came to States. From June 21st to August 21st, I was in States using my 60-day grace period of H1. And now, then later I didn't get a job. Later I got a job on the last day. They did not transfer my H1. Then I have to change to B2, the B2 visa right now, and the B2 visa is still pending. So what is the scenario like? I just wanted to ask, like, is it any unlawful entry here, or like what is the scenario for the future H1 transfer, or
There's always a suspicion of fraud here, basically, because you came in June. And your employer, I do not know what did you inform to your employer or not while you're coming into this country. And if you did inform your employer is supposed to hire you. You cannot there are some.
So initially we had an agreement. I had a plan to join back my company, but they have laid off again 600 people from my company, and they said maybe we are not going to hire you for next 2 months. September, in September they said they're going to hire me back, but there's no update yet. So completely I was in the dilemma, like whether to be here or not. But
it's possible that they may come back and question you, basically, whether you entered unlawfully into this country, basically by misrepresenting the fact that you have a job in this country, basically, when you don't have a job.
Yeah,
okay?
But but the initial talk was like they wanted to hire me, so that's the reason I came back. If not, they don't wanted to come back as well.
I mean, what do you mean by hiring? Intend to hire you basically because they have to have a job for you. You must have been
Okay.
already employed by them at the time you entered into this country,
Okay.
right? And
Yeah.
and that's the whole problem here basically with what you're telling me. Okay.
Okay. So right now I have applied for
I
B2 visa.
I would prefer talking privately. Okay.
I can, yeah.
Please. Please call my office and set up a time. We will talk time privately. I need to get more details. We don't have enough time right now to go through that.
Sure. Absolutely.
Yeah.
Yeah.
Thank you.
Yeah. Thank you.
Yeah. Next caller, please.
Hi, Bhanu. This is Kumar. I had a question regarding the status of EB1, EB2, EB3 application that is sent to the USCIS. Like, is that you who is going to set the visa category on my application, or is it the adjudicator at the USCIS who assigns that status to my application?
I'm sorry, Kumar, I didn't understand your question. Can you repeat your question one more time?
So now that we have been working on this EB2 to EB3 downgrade thing, I had a question regarding it. So if I submit my application, if it would be adjudicated as EB2 or EB3 by the attorney, or is it by the adjudicator who's going through my application, looking at my documents and all those details?
Attorneys have no authority to adjudicate your case, basically. Okay? Attorneys are just an agents to you to represent your case jealously before the USCIS so that you can get or approve the benefit what you're seeking from the USCIS. Okay? They are just your agents, basically. Okay? In reality. That's what attorneys are for. Attorneys have no authority to adjudicate your case. It is the USCIS with whom you're filing your petition, downgrade petition from EB2 to EB3. They are the ones who are going to adjudicate your I-140 petition, basically. Okay?
So they are the ones who mark the category as EB3 or EB2.
No. The category has to be marked by your employer through attorney. If your attorneys are preparing your case, then they are the ones who are going to seek the approval in EB3 category from EB2, basically. They're going to downgrade and they're going to file a new I-140 in EB3 category. They're going to ask the USCIS to adjudicate that matter in EB3 category.
Okay, so it is the application that you put as EB2 or EB3, and then based on the available documents, it's adjudicator who decides if it really belongs to this category or not, and then it's
absolutely whether you're eligible for the approval or not. Exactly.
Got it. Yep. Thank you, sir.
Thanks, sir. Next caller, please.
Hi, sir. Bhanu, sir. This is Srinivas. Good evening. The question is regarding the I-140. My I-140 is approved 2 months back. Actually, my employer is not going to share anything document related to that. So I would like to apply on FOIA request. I'm Googling it. I got the information. So is there any time period we need to wait to apply for that, like 6 months or 4 months, something like that? That is one question. And can I reach out to you through your office to process that?
Definitely, you can reach out to our office, sir. We'll be very happy to look into it.
Okay.
And whatever the cost and everything, we'll discuss at that time. Okay.
So do I need to wait for some period of time to apply for that? Just in September last week, it got approved by I-140.
There's no timeline like that, sir. You can ask for any time your FOIA request. You can make FOIA request anytime with the USCIS. That should not be a problem.
Okay. Thanks a lot, sir.
Next caller, please.
Hello, sir. This is Gautami here. Actually, I'm asking this question on behalf of my sister. She is on H1B, and she's like she done with her contract in the last month. So right now she is looking for the new one. Uh, so the thing is, she has some medical condition, so she wants to undergo some surgery. So can she able to put her medical certificate, and can she hold her payroll or running her payroll for a while?
What do you mean by running a payroll? Basically, I mean she can basically. I mean, I don't understand that when somebody tells me that. But one thing I want to tell you is this: basically, is this: if somebody is on H1B visa, H1B status in this country, they can definitely seek leave of absence without pay from the employer for medical reasons. Okay. And so if she has a medical condition that requires a treatment or some kind of a procedure, basically where she has to take a break from the job, she is definitely allowed to take from the job the leave, basically, as long as the employer permits her to take the job. I mean, take the break.
So for how long she can be like unpaid on H1B?
It is as long as it is reasonable. Sometimes it could be a month, it could be 10 days, it could be 3 months, it could be 2 months, it could be 6 months also, depending upon the situation of an individual, basically, right? And they should be able to document that tomorrow if any USAS comes with a query or anything like that on that issue. There is no such particular timeline given by the Department of Labor regulations, basically, or by the USA's regulations. As long as there is a bona fide reason for them to take a leave of absence without pay, and if they can establish that it was a bona fide reason for personal reasons, especially your sister case, which seems to be a very genuine reason, I don't see any problem at all for her. Okay, but our employer has to approve that leave of absence for her without pay. Okay.
Okay, sir. Yeah. Thank you so much, sir.
You're welcome. Next caller, please.
Hello. Can you hear me?
Yes.
Yeah. So I was just checking if you file EB1 green cards as well, EB1 extraordinary ability.
Yeah, we do, sir.
Okay, sir. So here is the thing. So even I was surprised when I first came to know that I might be eligible for that. Like a couple of years back, an attorney called from past, right? They have actually confirmed saying that okay, we have a case for you and all that. But then at that point of time, I had some H1B issues, and the extensions were like getting rejected and all those things. So I had to go back to India and come back. So I mean, after consular approval and all that. So now again, I'm in that sort of I can't say very critical, a good project. Like it's with the state. So do you think we can do it from, we can file a H1B, I mean, EB1 green card now?
Sir, as you are very well aware that EB1 have three categories, right? One is EB1A, EB1B, and EB1C, basically, right? And it's about one's qualifications. It's not just the job. They can look into the job also, but that is not the determining factor. It is about one's individual qualifications in order to qualify somebody for an extraordinary ability visa. Because that EB1A category, one can self-petition also. Okay? It doesn't have to have an employer. He himself can be himself an employer, and he can petition for himself also, as long as he qualifies for that, basically. Okay? That's individual qualifications. I do not know what qualifications you have and everything. Therefore, it's very difficult for me to tell whether it's okay to go ahead and file EB1A or not now. I think it's better for you to reach out privately.
Sure, I can do that. And absolutely. And one more thing is that, it's based off of the projects I have done, and also around 3 of the international letters, like one from the international university, in UK, and another one is from Norway, which is for a humanitarian organization and all that, and one is from Singapore. And these 3 letters are some things which I can get definitely with high regards and all those, stating that extraordinary abilities are definitely there and all that.
It's impossible for me to tell on this call, sir.
Sure, sure,
Yep.
sure. Okay.
I have to
So
review.
in that case, uh,
I have to review the information. Okay.
okay. So how do you want me to reach out to you, sir?
Call my office 703 496
Mhm,
7722
mhm.
and set up time. Tomorrow I'm on a break, so they'll be able to. I mean, I'm very happy to talk to you on Monday. Just schedule an appointment on Monday, sir. You know?
Okay, sure. We'll look forward. Thank you. Thank you, sir.
Yeah, sure, sir, definitely. Next caller, please.
Bhanu, I can skip, sir. You already answered the question. Thank you.
Sure. Next caller, please.
Hi, Bhanu.
Yes, ma'am.
So this question relates to the H1B. So I have an approved I-140, and it's been 5 years now. So, and I wanted to go back to India and stay there for like 6 months for some emergency reasons. So if I want to come back on H1, so is it possible without a dream job in India? So should I go through the lottery again?
You don't have to go through the lottery again because you already have an I-140 approved, basically.
Okay.
Oh. And only thing you need is say you need an employer who's willing to hire you and sponsor you H-1B visa. That's all.
Okay, that can be the existing one or the new one, anyone, right?
Anyone. The existing employer also, if he wants to hire you back, yes, they can hire you back.
Oh, okay. Okay. So, and one more question, the downgrading. Mine in the, so I see that EB3 is current in 2015. So mine also, my expiry date is in 2015. So would you suggest me to downgrade to EB3 or stay on the EB2 only?
When is your priority date?
November 2015.
I will not advise you to downgrade right now, okay? Because we do not know whether the filing dates will be opening for that particular date or not. Because if you look into the final action dates, it's in 2010 only. So I will not advise you to downgrade. Okay?
Okay, yeah. Thank you so much, Bhanu.
Sure. Next caller, please.
Hi, Bhanu, this is Anil here. Thank you for all the help with answering all the questions. This could be a repetitive question, but I'm not sure. See, right now I have filed for I-485, and as part of that, for EAD, we filled I-765, and for advanced parole, we filled I-131. Okay. And so when I get those, like, the EAD card, I heard I will be getting EAD card with advanced parole on back of the card. That's what I understood from my research. Okay. Now let's say, sorry.
Yeah, tell me, sir. Tell me.
Let's say that I go to India. I'm on H1B right now. Okay. I go to India. I come back on advanced parole at the port of entry. But can I continue using the same H1B over here? Because H1B petition is not expired though. It's still up. It's still valid.
Yeah. So if you, I'm sorry for that. And if you enter on the advanced parole, basically, pursuant to your adjustment of status application is pending, you're no longer an H1B in this country. You are a parolee based upon your adjustment of status application is pending. Okay, and because of that, you are not considered H1B status. In order for you to work, you have to provide proper employment work authorization. That is the copy. That is basically your EAD, basically. Okay.
Okay. So basically, job change or whatever job thing is like we are using advanced parole for travel, whatever. Vice versa.
Vice versa. H-1B visa, so you can continue working on H-1B status. But if you're not coming on H-1B visa, if you're coming on advanced parole, then you're seeking admission into this country as a parolee, pursuant to your adjustment of status application is pending. Therefore, you're in this country either as a parolee/adjustee, and therefore, in order to work for you, you need to have a proper work authorization. That is nothing but actually employment authorization document.
Okay. One last question on the same thing. When we enter on the advanced parole, so what is the status on the
parolee?
Parolee.
Yeah, adjustment of status.
Okay. I see. Thank you, sir. Very much appreciated. Have a great day. Okay.
I'll take one more call. Hello. 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 I think I'm glad this call has went very well today, and hope I was able to answer everybody who's on the Q&A today. And as I said, every Thursday evening 4 p.m. Eastern Standard Time, we have this conference call where we basically provide all latest updates pertaining to the immigration law, and then we open for Q&A to the people who are actually in the call and answer their queries pertaining to the immigration law. And hope you all are staying safe, and do feel free to reach us for any immigration needs you have. Our phone name is BBI Law Group 703-496-7722. Our email ID is contact@bbilawgroup.com or crm@bbilawgroup.com or bhanu@bbilawgroup.com. You may also schedule an appointment to our website also, bbilawgroup.com. Please stay safe. Please follow social distancing. Kindly wear a mask. And the COVID-19 is still not over, and people are getting infected heavily these times. And stay safe, stay healthy, and God bless you all. Thank you all. Have a wonderful day. Bye.
Goodbye.